Thank you very much, Aviva, and welcome to all of our Decalogue Society members as well as our Hinda Institute participants and attendees. We're thrilled again to have the esteemed Elizabeth Kelly as our speaker this evening. Elizabeth, we're very honored to have her. She is a renowned expert with a nationwide practice specializing in representing individuals with mental disabilities. Elizabeth is the editor of 4 books published by the American Bar Association representing people with mental disabilities, a practical guide for criminal defense lawyers, representing people with autism spectrum disorders, a practical guide for criminal defense lawyers, suicide and its impact on the criminal justice system, and representing people with dementia, a practical guide for criminal defense lawyers. Elizabeth co-chaired the ARC's National Center for Criminal Justice and Disability Advisory Board and served 3 terms on the board of the National Association of Criminal Defense Lawyers. Elizabeth is active in the ABA, serving as Vice President of the Criminal Justice Section Council, the editorial board of Criminal Justice Magazine, and having served on the ABA's Commission on Disability Rights and as an observer at the hearings at Guantanamo. She currently serves as the editor of the ABA's annual publication, The State of Criminal Justice. And without further ado, Elizabeth, welcome, and the floor is yours.
Thank you so much, David. And thank you for all of you for joining the evening about to discuss this hugely important topic. Would you please put on the first slide, Michael?
Oh, sorry, just
There's always a Zoom adventure. All right. And I think actually you can progress to the second. Thank you. If you emerge with nothing this evening, I want you to emerge with the following: that people, no, there we go, stay, thank you. That people who have a mental disability very rarely have only one diagnosis. That is to say, they have many things going on in their lives. And in fact, let's even back up more. Mental disabilities is my global term. It encompasses people not only with mental illness, issues like bipolar disorder, schizophrenia, and major depression, but also intellectual and developmental disabilities, issues like autism spectrum disorder, what we used to call mental retardation, fetal alcohol spectrum disorder. More and more, we're also encountering people with other issues like dementia. So as I was discussing a few moments ago, generally speaking, people with mental disabilities have what we call co-occurring disorders. Very rarely do you encounter an individual who has only bipolar disorder or only autism spectrum disorder. So for instance, you can have someone who is struggling with bipolar disorder, but also for a variety of different reasons, that person also may have substance use disorder. And it's very often difficult to know where the bipolar disorder ends and the substance abuse begins. Indeed, one feeds into the other. Similarly, if you have someone with autism spectrum disorder, they may have other issues going on. We know that approximately half the people who have been diagnosed with autism spectrum disorder may also have an intellectual disability. But keep in mind the term spectrum in autism spectrum disorder. It is indeed a wide and diverse spectrum. So you can have someone with a very high level of intelligence, but because of having been bullied as a child or as a teenager, or perhaps even as a young adult, They may suffer anxiety or depression. They may also have a sleep disorder. I tell you all of this because you, as lawyers, should be sensitive to and open to the complexity of your client's makeup, but also understand that all of those various issues are important when it comes to advocating for specific resources and accommodations, not only during the pendency of a criminal case, but also for the disposition of sentence, whether it is a non-custodial sentence, that is to say probation, or, God forbid, jail or prison. Next slide, please. The threshold issue in any criminal case is that of competency. And competency, or the floor for competency, was established in the Supreme Court case of Dusky v. US in 1960. And it basically says that in order to be competent to proceed, the accused has to have two different things. First of all, they have to have a rational as well as factual understanding of the proceedings, and, not or, and sufficient presentability to consult with a lawyer with a reasonable degree of rational understanding. In other words, they need to know what's going on, they need to know the gravity of what's going on, and they need to be helpful to their lawyer, whether it's providing a cogent narrative of events, perhaps providing a list of helpful witnesses, perhaps providing an alibi, perhaps giving a reason for the conduct charged. Competency, keep in mind, measures the accused's level of functioning at the time of that legal proceeding. From the moment that person is in custody, all the way through, as perverse as it may sound, the time of execution. This is a continuing inquiry, and counsel should and must always be vigilant as to their client's level of competency. Next slide, please. And I have included the Illinois statute here. Next slide, please. Now, veteran criminal defense lawyers will tell you that, as a practical matter, competency is a rather low standard. And David and Michael have heard me make this joke many times. There is an old saying that a grand jury could indict a sandwich. And my variation on that theme is a grand jury or a court could find a sandwich competent to proceed. However, there is, for want of a better phrase, a legal fiction called restoration. So if a court determines, after reading evaluations, after perhaps conducting a hearing, that an individual is incompetent to proceed, the court requires that that individual undergo a period of restoration. Now, think about that concept in light of that first slide I showed you about the different kinds of mental disabilities. If, for instance, you have someone with bipolar disorder who, if in fact he or she did commit the act with which he or she is accused, may have done that because they are off their medications. So the fix would seem easy. You put that individual in a structured environment. You give that individual the proper medication in the proper dosages at the appropriate time, and that person is restored to competency. On the other hand, think about a client with dementia. As I often tell families who have a loved one with dementia, once that individual falls off the cliff, there's no bringing him or her back up. The most that can be done in that situation is management. On the other hand, you may have someone with an intellectual disability, someone with a low IQ. So again, you can put that person in a structured environment. Maybe it's inpatient restoration, maybe it's an outpatient program with lots of classes about how the court system operates. And you can teach that person to parrot back answers, very superficial answers to what is the role of a judge? What does a prosecutor do? What does a defense attorney do? What's the difference between a plea and going to trial? And that person can give you a response, but it's really not going to have any depth of understanding. And if you quiz that person, once that person is out of the restoration classes, the restoration environment, chances are very healthy that that so-called restoration will not stick. There are some jurisdictions, depending upon the statute, which will dismiss the charges if someone is found incompetent to proceed. In other jurisdictions, depending upon the statute, the court has a time limit during which that individual can be restored. But understand, or should be restored, but understanding your client, understanding the complexity of his or her diagnosis or diagnoses is key. Next slide. The inverse of competent to proceed is insane at the time of the act. This measures the person's capabilities, the person's state of mind at the time of the alleged act. And contrary to what the popular media says, defendants are not willy-nilly and randomly entering pleas of not guilty by reason of insanity for a number of reasons. First of all, as a practical matter, the standard for insane at the time of the act is a very, very high one. Indeed, following the attempted assassination of President Reagan by John Hinckley, the federal standard was tightened and various states tightened their definition of insanity. So a good criminal defense lawyer knows what high a mountain that is to climb. By the same token, the most successful insanity defenses are usually mounted in circumstances where a forensic psychologist or psychiatrist met with the accused almost immediately after the alleged act. And for instance, that forensic psychiatrist can see the individual in a floridly psychotic state. This type of immediacy to the time of the alleged act is crucial, particularly for individuals in custody. Because if someone is taken into custody, chances are healthy that the jail or prison or the jail is going to start medicating that individual, if nothing else, to calm him or her down. And you want your expert to meet with that individual at that time before the meds have kicked in. You want as accurate a picture of your client's state of mind as possible. Next slide, please. And again, the next slide is simply the Illinois statute. I've alluded several times to the expert. And Michael, can I get you to move that slide just a little bit over towards the left so I can see it better? A little bit more. Thank you. Perfect. I have alluded to the expert. Now it left. Could you bring it back? I have alluded many times to the forensic expert, both the forensic psychologist and the forensic psychiatrist. Typically speaking, a psychiatrist is brought in for mood disorders, conditions like bipolar disorder and schizophrenia. On the other hand, a forensic psychologist is most often brought in for intellectual and developmental disabilities, in large part because of the testing that's administered. But it's not a hard and fast rule. There are a number of key concepts. Michael, can I get you to, yeah, perfect. Just keep it like that. Thank you. It's important to recognize a few key concepts about the forensic psychologist or psychiatrist. First of all, you need to emphasize to the individual being evaluated and or to the individual's family, and perhaps even to the court, that the treatment provider cannot be the forensic expert for a variety of different reasons. The first is, it's basically a conflict of interest. That is to say, if a doctor has been treating an individual for a number of years, it puts that individual in a very difficult position when if that expert is called upon to render, to talk about that person's propensity for future violence. Beyond that, the expectations of confidentiality that a treatment provider has with his or her patient is very different than the expectations of confidentiality that a forensic expert has. A treatment provider in the very beginning says that it is important for you to tell me everything and I will hold everything in confidence. However, a forensic expert begins with a disclaimer that everything the individual tells that expert will be available for their lawyer, for the prosecutor, and for the court. And finally, it's important to remember that a forensic expert has very, very different skills than the treatment provider or the clinical expert. Forensic experts are taught how to testify at a hearing or a trial. They are taught how to write a forensic evaluation. They are taught how to work with the defense attorney or the prosecutor, whoever engages them. As early as possible, you as the defense attorney should get your expert. The first reason is practical. Ever since the pandemic, good clinical, good forensic experts have been in great demand, not only because the courts have now opened up, but most forensic experts have a clinical practice. And ever since the pandemic, there have become more and more people seeking mental health care. And as a result, experts are busy, often months in advance. So you need to find out when your expert can see the client, when the evaluation can be conducted, when the collateral interviews can be conducted, when the records can be reviewed, and when they in fact can have a draft of the report to you. As early as possible, try and identify the purpose for which you want your expert. It may very well change as the case evolves, but try to at least have an idea up front. Do you suspect that your client is not competent to proceed? Do you suspect that your client was insane at the time of the act? Do you think that your client is not served by either one of those definitions, but nonetheless, you know that your client has mental issues, and you need and want those to be explored? Perhaps it's to negotiate a better plea, and or perhaps it's to mitigate whatever sentence the court might hand down. Perhaps it's an evaluation to get your client admitted to some type of problem-solving court, whether it's a behavioral health court or a veterans court or a drug court or a what have you. Where can you find an expert? If the court appoints an expert, then for better, for worse, you may not have much choice. But if you know that your client has a very particular kind of issue, like autism spectrum disorder, like FASD, you can reach out to your colleagues. That is often a good source of referrals, but just do some preliminary research. See who's done presentations on this subject. See who has written on this subject. And also you can certainly post on listservs, but please, I beg of you, and I sadly have seen this before, don't divulge anything that's confidential. Be very circumspect with your inquiry. And finally, be open to the fact that you may very well need to have a team of experts. So for instance, if you have a client who is on the autism spectrum, you may need to have an expert who does the forensic report, but then you will also need to bring in a special expert to administer particular kinds of tests to assess the client's propensity for future dangerousness. That is to say, to answer the court and the prosecutor's perennial concern that that client may very well commit this type of action again. Next slide, please. Okay, ooh, whoa, too far, too far. Yeah. Oh, I guess we did. Yeah, you're fine. The next slide. Yes. The evaluation. There you go. A thorough evaluation contains many components. First of all, it contains an interview, preferably multiple interviews with the accused. And I say this for a variety of different reasons. First of all, the initial interview could simply be an opportunity to bond with the expert. Depending upon your client's mental issues, your client may also have significant trust issues, and developing that bond is key. Also, a thorough interview may be a very draining experience, and it is the better part of wisdom if your expert can break that interview into a couple of days of interviews. Beyond that, your expert may want to evaluate your client over a period of time, other words, to get the full arc of your client's presentations. Also, releases may need to be signed. And sometimes it's just too early in the relationship for that initial meeting to include a client's signature, allowing that expert access to the most private of medical treatment. Also, a good forensic expert will conduct a variety of different collateral interviews with family, friends, coworkers, anyone who knows your client well. Among other things, what this will do is diffuse any accusations that the court or the prosecutor might have that your client just conveniently brought forward this condition because of the accusations against him or her. If you can point to the fact that your client has suffered for years with this particular issue, if they have an intellectual or developmental disability, they may have suffered this, or they may have been diagnosed close to the time of birth. By the same token, if your client has bipolar disorder or schizophrenia, your client may have started manifesting the symptoms in late teens or early 20s, the typical case of, or the typical age of onset. On the other hand, if your client has suffered a traumatic brain injury or suffers from PTSD, it may be important and significant for some people to talk about your client as he or she was before the accident or before the traumatic event, and now have others talk about what your client is like now. A good forensic expert will review all sorts of documents, treatment records, school records, records from the VA. They will also review all the discovery in this case, good as well as bad. This too is a key difference between a treatment provider and a forensic expert. Treatment providers will not review in detail the discovery materials. A forensic expert will. Also, depending upon the diagnosis and depending upon the examiner's training, that examiner will conduct a battery of different tests. And finally, all of this can be used in a variety of different ways. If, as I said before, if the concepts of competency and insanity would not serve your client, a very thorough evaluation could be powerful in terms of leveraging a better plea, or again, depending upon the nature of the charges, depending upon the jurisdiction, and depending upon what, if any, prior record your client has, dismissal of those charges. Next slide, please. This is a chart that was put together by Dr. Jonathan DeWright of Baltimore, Maryland. He is a forensic psychiatrist who specializes in dementia, and he puts from the perspective of a psychiatrist, he has many do's and don'ts. Probably the most important on there is do share all the discovery materials with the expert. And from the expert's perspective, this is key for a couple of different reasons. First of all, a good expert can probably come up with an explanation for just about everything. And they can do it in a very thorough way. They can do it in a learned way. They can do it in a way that probably is very persuasive for the prosecutor and the court. Also, a good expert wants to have reviewed everything in order not to be made vulnerable during a hearing. If an expert doesn't know about a bad fact and doesn't account for a bad fact in their evaluation, they will be cross-examined about it during a hearing or during trial. And they will probably be embarrassed about it. And the cross-examination basically writes itself. That is to say, doctor, do you know the following? If you had known about the following, would it have changed your opinion? Afterwards, the doctor will become, you will lose a certain amount of credibility, but beyond that, you yourself will lose credibility in the eyes of the expert from that point forward. Next slide, please. And I already discussed a bit about the uses of an evaluation. I would also like to add that it is not unheard of for you as a defense attorney to bring your expert into a meeting with the prosecutor. There are a number of prosecutors who sincerely do want to learn and will appreciate the opportunity of hearing from your expert and also the opportunity to ask questions. I will wrap this slide up by saying there indeed are some prosecutors out there who do want to do the right thing, particularly when it comes to an individual who has a mental disability. Next slide, please. Depending upon the disposition of the case, you will need to create a path forward for your client to ensure the prosecutor as well as the court that your client will not be a danger to himself, but more importantly, will not be a danger to the community. And you will need to discuss a variety of different supports that will need to be in place in order to ensure that. For instance, if your client needs treatment, if your client will benefit from treatment, outline that course of treatment, whether it is medication, whether it is anger management, whether it is skills to help him with executive functioning. All of this is particularly true in the case of younger clients who have their entire life in front of them. And it can be powerfully persuasive if you outline for the court the educational path your client will follow in order to ensure that he or she does not get into this type of trouble again. Most mental disabilities will last a lifetime. And it's important not only for your client and your families to understand that they will continually have to deal with these issues, but it's important that you impress upon the prosecutor as well as the court your client and your family's understanding of this and their plan in order to manage those conditions through the coming decades. Also, it's important to outline for the court where your client is going to live, with whom your client is going to live, how your client is going to be supervised if in fact your client does need supervision. And again, particularly in the case of your clients who are younger, who maybe are in trouble for the first time in a significant way, and for whom this offense could be a significant impediment, it's important that you show that your client does indeed have a future, that your client wants to continue in school, that your client might need financial aid, that your client may want to apply to graduate school, that your client may one day need to sit for a bar exam, and that this particular criminal case may be a real game changer in the negative sense, and that you are asking the court to enable your client to become as successful and productive as possible, notwithstanding this unfortunate occurrence, and to continue with their schooling. By the same token, your client may very well be in a position to work. In fact, it may be important not only for your client to work, but for the support of the client's family. And indeed, impress upon the court the importance of this and enabling and empowering your client in the future. Next slide. Jail or prison conditions. In my opinion, in most cases, jail and prison is the worst possible place on the planet for an individual with mental disabilities for a host of different reasons, depending upon the nature of their their individual disabilities. For instance, you may have a younger client who is simply young and naive, who can be preyed upon not only physically, but also emotionally. You may have a client who, granted, is a bit older, but nonetheless is capable of being manipulated, whether it's a very streetwise inmate contacting the families, the individual's family for protection money or something else, whether it's a streetwise inmate who manipulates your client into doing something that's against the regulations, or indeed may even be unlawful. Also, sometimes clients with various kinds of mental disabilities have a fundamental inability to follow the rules. They may simply not comprehend what the rules are, or by the same token, they may be rather argumentative, not because they're trying to be obstreperous, but for instance, they're on the autism spectrum and they question and they clarify. It's who they are. In the outside world, that questioning, that need for clarification may have been a superpower, but in a jail or prison, it can often be lethal. You may have a client with dementia who is simply unable to even comprehend orders, who may have difficulty with hygiene, and as a result is not only punished, but is probably ostracized. Sometimes people with mental disabilities are, in fact, punished for manifesting the symptoms of their disability, and as a result, they're written up, they're put into solitary, where they may, in fact, suffer from additional traumas. If they are sentenced to prison, and you're trying at some point for early release, or if they're in jail and you're trying to get them out on bond, disciplinary infractions will weigh against them. You also may have a client, particularly if your client is on the autism spectrum, who, excuse me, who may have particular sensory challenges. He or she may be sensitive to bright lights, i.e., fluorescent lights in jail, which are on 24/7. He or she may be sensitive to loud and sudden noises, like the yelling of other inmates, like the banging on bars. He or she may have very, very real sensitivities to different kinds of foods with different kinds of textures. He or she may have different other kinds of sensitivities, like the scratchiness of a jail uniform. All of this can make jail or prison torturous for someone with a mental disability. It's important that you have documentation for this, expert documentation for this, that your forensic evaluator address this in some fashion, either at a hearing or in their evaluation, or that you engage a jail or a prison consultant. I know that sometimes jail and prison consultants get a bad reputation, but believe me, there are some very reputable ones out there who can address these conditions. And finally, you need to show that outside the jail or prison environment, your client with a mental disability will not only be free from these horrible conditions, but because of the path forward that you've outlined for the court, will not get in trouble again. Next slide, please. Before I wrap up, as David said in the beginning, I have written a few books, and at the risk of sounding self-serving, there are their titles. I am also happy to talk with any of you and answer questions, not only during the period of Q&A this evening, but also if you want to reach out to me through my social media or through my email, I am happy to answer questions or concerns, or simply just to brainstorm with you. So with this in mind, I am now open for any questions or concerns that people might have.
Yeah, people can post their questions in the chat. I know this was a lot to take in, so I'm sure that you've got some questions if you stop to think about them, and please put them in there.
One thing that I neglected to mention on that initial slide with co-occurring disorders, you may remember that under mental disabilities, I had mental illness, and then I had intellectual and developmental disabilities. But you should also not ignore the fact that your client may be a younger client. That is to say, he or she may indeed be 18, an adult in the eyes of the law. But we know that the brain is still developing into the mid-20s. So your client may very well come to the table with a mental illness and or an intellectual disability, but your client may also be young. So that brain is still developing. And you should account for that as well. And you should also address that fact at the time of sentencing in terms of the vulnerabilities that I laid out for you in one of the last slides about jail and prison conditions.
Okay, we have a Linda Jacobs raising her hand.
Yes, what is your question?
I just found the answer in a prior chat link that was done. Thanks, though. Sorry, I'll lower my hand.
No
Sorry.
worries.
Excellent
No worries.
presentation, by the way. Thank you.
Thank you. Well, I'm feeling like a complete and utter failure because there aren't any questions. So I've either lost all of you or you've completely tuned out.
Ms. Kelly, allow me to qualify that, if I may.
Sure.
I think people are now processing
Okay.
some of your very good information. So we have Nancy Dangerfield raising her hand, and we have a question in chat from James Heinemeyer. So Nancy, why don't you go first, and then I'll read James's question. Nancy, you're on mute. I'm sorry.
Okay, I was just wondering if there was anything that you encountered with sexual assault on the prisoners with mental illness by the guards, because that's what happened to my son.
Ouch. Oh, I am so sorry. I am so sorry. Um, the cases that are top of mind for most defense attorneys, particularly federal defense attorneys, are the offenses committed against women at Dublin, the federal prison in the Bay Area, and the Bureau of Prisons, I guess in a moment of resignation, just shut down that facility. And the media, thankfully, has done a relatively good job of covering just how dangerous and despicable that environment was.
Yeah.
So, yeah, I mean, it's,
I mean, and
that-
even the males, it happens
Yeah.
to the men as
oh,
well.
yeah, yeah,
And then
by all means, by all
Yeah.
means. I mean, it has long been the dirty little secret of the penal system in this country. And we have laws against it. We have substantial penalties for those who are convicted. But to state the obvious, the fear of reprisal within jails and prisons is huge, to the point of being debilitating. And that type of fear is true not just for sexual assaults, but it's for any type of infraction.
Right.
I have clients with mental disabilities who are in facilities, and other inmates make fun of them. They take the food off their trays. They bully them. They make fun of them. They make their lives miserable. But they're afraid to tell the COs for fear of reprisal, whatever form that reprisal may take.
Well, in my son's case, he did submit a grievance and also refused that guard, what he was trying to do. And so he made up an allegation about my son, and he was put into solitary for one
Yep.
full year.
Yep.
So, he ended up even possibly
Yeah.
worse off.
Yeah, yeah.
Yeah, it's hard to fight it.
Okay, Ms. Dangerfield, do you feel that you've had your a fair response?
Oh, was that for me?
Yes, ma'am.
Oh, yes, thank you very much.
Yes, thank you. And I'm so sorry for that situation. Thank you. James in chat asked, what will President Biden's mandate that private insurance providers treat mental health with the same care as they treat physical health mean for incarcerated people? The federal mandate has been in place since 2008. Mental health care in prison is virtually non-existent.
Yeah, I'm nodding my head. I'm nodding my head. Yeah, I mean, I can't speak to all state Department of Corrections, but the Federal Bureau of Prisons is a world unto itself. And I don't want to say it's accountable to no one. I think Colette Peters is trying, but she has inherited generations of dysfunction and underfunding and a culture that is not about treatment or rehabilitation. It is about punishment and incapacitation. That being said, the district court judges are, I don't want to say regularly, granting federal motions for compassionate release. But that is a vehicle for relief, which is now more available than it has been in the past. We thought that maybe during COVID, compassionate release would be limited to that point in time. But now throughout the country, we are seeing federal district court judges recognizing that negligent medical treatment, lack of proper mental health treatment may be grounds for compassionate release. Beyond that, I like to think that changes in the laws will lead to a change in attitudes, a change in the stigma against mental disabilities, and that at some point in time, that change may filter into our jails and our prisons, both at the state as well as the federal level. But as I said during my presentation, bottom line is jail and prison is the worst place in the world for people with mental disabilities. And if we can stop this at the front end, if we can have vigorous advocacy on the part of criminal defense lawyers, if we can get prosecutors and U.S. attorneys to come off the charges that carry mandatory time, if we can give judges the discretion to sentence to something other than prison, then many of these problems will be prevented.
Thank you. And we have William Piccini, who has been waiting very patiently. William.
Hey, can you hear me?
Yes.
Yes.
Okay, thank you. Great topic. I appreciate your time. I have a question. I've been in and out of the justice system since I was young for like fighting, and I had a witness intimidation. I don't think I have any mental disorders, but like because I started so young, I got to see how the court system worked from like juvenile up until adult. I've done time in state prison in California. Like that's probably the worst prisons in the country. And I mean, I've been in and out of the court system, and I did my own appeal, and I started to, dabble and study the law. And I really realized how evil the system was when I read the Black Laws Dictionary, and you're able to look up, certain terminologies that are different than what would be in like the Webster's Dictionary. And you're like, man, these guys hate our guts, So I've seen a lot of people with serious mental problems who weren't even really in there for like real serious or violent stuff. Like I have my opinion on violent crime and how it should be dealt with, but like people that are in and out of the court system, they have really bad mental problems. They're in there for something not even that big a deal, and they're getting ready to go to prison. So what advice would you give to somebody who had mental problems, who was going through the court system, and they don't have friends, they don't have family, they're kind of on their own, they're going to be stuck with a public defender, and we all know that the amount of effort a public defender puts into the case is slim to none. And a lot of times these public defenders are buddies with the prosecutors, and they're making deals for, like, some public defenders are private attorneys who are representing people in jail, and they'll work deals to get that guy off, to sacrifice you. What would you say to somebody? What would you say to somebody that has nobody and that needed the kind of help that you were saying would be helpful in a situation with the court system?
Sure. No, you've raised 1,000 different issues. Let me put an asterisk on something that you said towards the end. about
Okay.
public defenders and court-appointed lawyers. You've got in the system, I've worked with them, I've known them, some
Uh-huh.
very, very fine public defenders, particularly federal public defenders. You have some public defenders who have literally devoted their lives to what they see as their calling. And pound per pound, they are as good as any lawyer in the country. By the same token, there are some superb court-appointed private attorneys, again, particularly in the federal system. And I will say this, in my youth, I did court-appointed work. That was probably some of my best lawyering because I was young. I questioned everything. And I was energetic. And I was filled with idealism. Now, I haven't necessarily lost my energy and I still remain hopeful, but nonetheless, I like to think that some of the folks who I represented in my youth were very, very well served. That being said, if someone is out there and they truly do not have any resources, it may be that their public defender or their court-appointed attorney may be looking out for them. Also, depending upon where they're charged and what they're charged with and what their issues are, they may be eligible for a problem-solving court or some sort of diversionary program. We have literally thousands of problem-solving courts now throughout this country, something that could not be said 10, 15, 20 years ago. And those courts are a wonderful option, particularly for first-time nonviolent offenders. And that would prevent some of the tragedy that you saw a number of years ago. That is to say, people with issues who were in prison who really should not have been. So as I said, you touched upon 1,000 different issues, and I hope I've given you some good food to chew on.
Thank you. So now we have quite the queue. Alan Ryan wrote, in Illinois, cash bail was stopped, and the decision of whether to keep an accused in jail pending trial is a question of danger to the community. Given the short time before that determination is made, what would be the best approach to presenting an expert as to the danger of the accused if they are released pending trial?
Do you mean, is it good to produce an expert for reduction of bond?
I will see that to Mr. Ryan if he's available. Are you still here, Mr. Ryan? There you are. Would you like to
Elaborate
unmute?
upon your question?
Yeah, I mean, Illinois doesn't have bond anymore.
Yeah,
So, and typically the hearing on whether to release the person is within days of their arrest, if not the next day. So how would you be able to find an expert,
yeah,
get
that's,
the expert to do the interviews before that determination is
yeah,
made?
it's a quick turnaround. Yeah, you can't just pick up the phone and ask your expert to get into the jail in a couple hours. And I confess, I don't know the intricacies of Illinois law. Is there an opportunity if bail is not granted initially to revisit the issue in the coming weeks?
Okay, I don't really do criminal law, so I don't know if there's an opportunity to revisit the issue in the
Yeah,
future.
I would think that there would be. So if, for instance, if bail was denied after a short amount of time, and then the attorney found an expert, the expert interviewed in whatever fashion the client, and then did a report, then a motion could be filed with that report as an exhibit. I would hope that there would be the opportunity. I mean, one thing about criminal defense lawyers, we as a species always have one more trick up our sleeve. So if the court denies one thing, we either go back and ask for it again, we ask for it again differently, or we ask for something else in the alternative.
All right, thank you. So we have two hands and one chat question. I'm going to take the chat question first, and then it'll be Stephen, Ms. Gubin. Just a moment. Question from Will: what, if anything, can be done to overcome the blanket immunities that state and federal prison systems administrators, personnel, and medical staff enjoy? So that's sovereign immunity, basically.
Yeah, and that goes back to the very first question about sexual assault in prisons. Unless and until the laws are changed, very, very little. The immunity that governmental officials enjoy is often a barrier to filing civil rights suits. And we need more qualified civil rights attorneys in this country. There are many meritorious cases that are never filed, particularly in rural and underserved areas. That being said, I talked a little bit earlier about giving judges sentencing discretion. Little will change in our country unless we as citizens tell our lawmakers at the state and the federal level that the criminal justice system is broken, that there were many well-intentioned laws that have grown overbroad and that have created a whole new set of abuses. And we need to rethink the system from beginning to end. And
All right.
we have one more bit about my commercial. Our election we have elections in a matter of weeks. And it is all too easy to vote for the candidates who say, I will be tough on crime, I will keep our communities safe, et cetera, et cetera, et cetera. That type of zeal is admirable, but that zeal should be tempered with discretion and in many cases mercy. And we need to elect individuals who are capable of that.
Thank you. And Steve, you've been very patiently waiting. Nope, you just remuted yourself, Steve. One more try. Can you unmute yourself, Steve? We can come back to you if you want. Oh, there you are.
Okay, I got it unmuted. Thank you. Thank you very much for your presentation. One thing that I'd like to point out that I have found is also with probation, one of the questions that is frequently asked is about if you've ever received special education in school. And a lot of people don't know what it may have been. However, it's there to admit to it immediately, because that is a form of protection, and then possibly getting IEPs and other things, it can segue to that. And it's something to keep in mind that it occurred at an early age.
Yeah, that's a great point. That's a great point. And a good forensic psychologist or psychiatrist is going to cite the fact that an individual had an IEP or was given special accommodations or in special classes.
Excuse me, I shouldn't have said that. An IEP is an individual education program.
Sure.
And also, even something as simple as speech, which leads to a language issue, even in birth to 3. So it's something to consider when you're trying to advocate.
Exactly, exactly.
Thank you again for your wonderful presentation.
Oh, thank you for listening.
Thank you. And Ms. Gubin, thank you for waiting. You're on mute, please. Unmute yourself.
It's not, you have to unmute me. I can't.
You're unmuted now. You're
Now I
fine.
am. Okay. I have a question concerning, we were discussing younger people and that they should not necessarily, and I agree with it strongly, be held in custody. Years and years ago, I represented a young man who everybody agreed had a problem. The judge and the state's attorney were very willing to try and work something out. The problem is that the parents, the young man was 16 and physically more than an adult.
Yep.
All right, so his size, and it was pretty intimidating for the parents, were uncomfortable with him being home. And so it was a matter of finding placement for him. And what do you suggest happens while you're trying to find appropriate placement when you've got the judge and the state's attorney agreeing, yes, let's work this out. And the parents, we're not comfortable with him coming home.
Yeah. No, that's a common problem. And it doesn't matter whether you are in Anchorage, Alaska, or Sioux Falls, South Dakota, or Midtown Manhattan. We do not have enough resources. We don't have enough of the appropriate kind of resources. And also, we've got people with mental disabilities now live longer than they used to. Many of them are living at home, and their parents are getting older, and their parents are not physically able to take care of them. And we're facing a crisis in this country with that population, and their adult siblings may not be able to or may not want to take them in. We also have different kinds of facilities who categorically exclude some people. If they've committed a crime of violence or a sexually oriented offense, they may be too high functioning, they may be too low functioning. I mean, it goes on and on and on. Yeah. But by the same token, I have gotten so that I warn families up front if they're telling me that they have found this particular facility, and this facility is happy to take their person and or take their loved one, and the family is desperate. They know it's important to take care of the problem, and also to show the court that they're taking care of the problem. And what I always warn them is there are a lot of for-profit facilities out there, and they're happy to take your money.
Except my experience,
Hang on,
unfortunately.
let me finish this
Sorry.
up. Hang on. There may be some that will be perfectly appropriate. There may be others that are inappropriate, in which case they will do more harm than good. So I always ask those families to allow me to do a little bit of due diligence to make sure that they are credentialed by the appropriate authorities, to talk to people who have been through that program, just to make sure that it's sound. I'm sorry, go ahead.
I was gonna say, unfortunately, there are also several that are more than willing to take your money and then don't do what they're supposed to do.
Yeah, yeah.
And that's a major issue.
That's true of across our economy, sad to say.
Very sad to say.
And they take advantage of people when they're at their most vulnerable.
Yes.
Thank you so much for that question, Ms. Gubin. Would anyone else? We still have about 13 minutes left. If anyone would like to follow up with the question.
Actually, I'd like to ask a question. Are there any specific jurisdictions that do this really well, that have a good approach to dealing with people with mental health issues, that could be considered like a model that other jurisdictions could emulate?
There are some judges who operate very good mental health courts. Judge Ginger Lerner Wren in Broward County, Florida. He is now retired from the bench, newly retired from the bench. Judge Stephen Leifman in Miami-Dade County, Florida. He was a real pioneer in calling attention to the plight of people with mental disabilities in the criminal justice system. There are some programs that are good. If you must send someone to jail or prison, I reflexively don't like it. But for instance, in the Commonwealth of Pennsylvania, there is a special unit at the prison in Albion that is designated for people with intellectual and developmental disabilities, that has specially trained staff. Also in the federal system, there is a program called the Skills Program, but it's only at 2 institutions, and it's a drop in the bucket of need. Similarly, there is a dementia unit at the Federal Correctional Institution at Devon's. I think it only takes 35 people. And given the growing number of aging inmates, as well as inmates coming into the system who are older and have cognitive issues, it is another drop in the bucket. But there are some steps, and periodically you read of different jurisdictions who are instituting behavioral health programs or veterans courts courts. And those are all admirable. The problem is so widespread that and deep-seated that we as a society have not yet, if you will, seen the difference, but we're becoming more sensitive to the issue and the need for alternative programming and an understanding that what we've been doing for 50 years is just not working.
Thank you.
Okay, we do have Mr. Michael Jordan with his hand up.
Michael Jordan?
An attorney, I assume.
All right.
Oh, I'm sorry. I just
A retired judge, actually.
Oh, excuse me. Let's go
My
up that
question-
ladder.
My question is, when an individual presents themselves to a lawyer, or in my case, a lawyer presents themselves to me to mediate or to arbitrate, or I get to meet the clients in the process, how do we as lawyers know that there is some issue? What's going to be the key trigger?
Yeah.
You
Yeah.
can sometimes know by the charge or the complaint, but not always until
Yeah.
you're into it.
No, great question. If they tell you right off the bat, I have bipolar disorder or I'm on the spectrum, then it's easy. On the other hand, we as lawyers, I like to think, have a really good sense of radar. And we know that something is just a little bit off. We may not know the name. And again, it depends upon the particular diagnosis. So someone with bipolar disorder could be extremely nervous and extremely needy. And then all of a sudden talking and talking and talking and talking and talking. That's the mania. Or they could be almost despondent. That's the depression, the highs and the lows. You could, if you have someone with an intellectual disability, there may not, if you will, be physical manifestations of that, but you'll notice after a series of a period of time that they say yes to everything that you say, but they really don't expand upon it. They don't elaborate. They don't ask questions. They just want to please. And after a while, you realize that they're very childlike and they're very vulnerable. You could have someone on the autism spectrum who just, is not necessarily like Rain Man, but they are extremely focused and seem to lack social skills and seem to lack executive skills and executive functioning. You may talk to someone who is just extremely grandiose. You may talk to an older person who is really kind of delusional and not with it. As I said before, you may not be able to attach a name to any of these or other behaviors, but you know that in the panoply of human behaviors, this is a bit odd. Now, odd and even eccentric is wonderful. It's what makes humanity interesting. But it's when those oddities are so pronounced that they're debilitating, that it becomes an issue. And indeed, it might be that which led to the criminal conduct. Or in the alternative, it didn't lead to criminal conduct of any sort, but it may have made that person be look very suspicious, such that law enforcement set their sights on them. If you have access to a good forensic psychiatrist or psychologist, hopefully you can just pick up the phone or shoot an email and say, this is what I heard, without, of course, breaking any confidentiality if there is a confidential relationship. And it could very well be that that expert can give you some pointers about how to better communicate. It could be something as simple as, if you have a person on the autism spectrum, don't use figures of speech. Speak very, very concretely. If you have a person with an intellectual disability, in order to ensure that they truly do understand what you're saying, ask them to repeat back what you just said. So, but again, great question, and I'm glad you raised it.
And I've used many of the techniques that you've just outlined to that end.
Great minds think alike. Good.
Thank you.
Other questions, concerns?
I do see there is one person who's raised his hand, William.
William, just before you speak, we are running out of time, so if you could keep it brief, please. Thank you.
This is what I want to say. Don't you think there should be a stopgap measure and everybody should be evaluated so everybody is on an even playing field? And the reason why I say that is because I've seen a lot of crazy people in prison or mentally deficient that shouldn't be there. They're in danger because they can't follow the politics. They don't keep up with hygiene. And I would say to myself, this guy was obviously overlooked, because it's apparent even to me, who's untrained and not a professional, that this guy shouldn't be here and his life's in danger because
Yep.
he was kind of processed through like cattle.
Yep.
Don't you think like there should be a law to where everybody stops and takes their time to evaluate a person? Because if you're truly crazy or mentally deficient, you're not gonna tell your lawyer, hey, I'm crazy, or I have bipolar disorder, or I have ADHD, or I have this. A lot of people are so out there, they don't know that they're that bad.
Yeah. Well, and we only have like 1 minute left. So first of all, a good lawyer should be able to pick up the signals and do something about it in terms of getting an evaluation. But beyond that, more and more, well, certainly in the federal system, but even more and more in the local jails, there is a preliminary screening process to see if someone has a mental illness or an intellectual or developmental disabilities. Sometimes they're given appropriate medication. Sometimes they're put into special units. Sometimes not. But yeah, your points are well taken.
Thank you so much for that response, Ms. Kelly. And I think with that, I'm going to give the floor to David Grosky for the wrap up. But I do want to say before I give the floor to him that I so much admire your experience, sagacity, and still youthful passion.
Thank you. Thank you. I appreciate that. Some days are easier than others, but I am gradually seeing changes in our society as well as in the criminal justice system. And organizations like HINDA are in large part responsible for that. So I thank you.
Thank you, David.
Thank you, Michael, and thank you so much, Elizabeth, for joining us again this year. And thank you to all the Decalogue Society members and the HINDA Institute participants and attendees this evening. I think it was another great success with Elizabeth's presentation, as it's always been. And we look forward to having her as a guest speaker for the many years to come.
Thank
And we
you.
look forward to next week. We have a very esteemed second speaker for the Decalogue, second piece to the Decalogue sessions with our legal panel. With Harold Hirschman, we'll be speaking specifically to the healthcare system challenges within the prison system. He has been lead counsel on some very interesting and successful outcomes on those issues. So we look forward to seeing you next week. And again, thank you so much, Elizabeth.
Thank you. And good night, everyone.